Hello, everyone. I think everyone is here, so we can start our webinar. It's lovely to see everyone in one group. That's beautiful. So, hello and welcome, everyone. I delight to have you all here with us for our webinar. And before we begin, please note all the attendants that today's webinar will be recorded. The recording may be used for our company's website, social media platforms, and other public communication. But remaining in this session, you consent to recording and possible use of the material for educational and informational purposes. I will start with my introduction. My name is Tamara Bramidze, and I'm a lawyer specializing in international reproductive law and surrogacy coordination. I'm based in Georgia, Tbilisi, and I will be your host and moderator for today's session. The aim of this discussion is to provide clear and comparative legal insights into international surrogacy frameworks. Particularly, we will focus on Colombia, Argentina, Mexico, and Georgia, which focus on legal certainty, parentage, and risk management for intended parents. As everyone knows, surrogacy remains a legal framed field with countries adopting very different approaches from fully regulated system to legally undefined practice. As a result, intended parents face not just emotional and logistical challenges, but also significant legal uncertainty, depending on where they pursuing surrogacy. So that's why today's session will follow a moderated question and answer format rather than just formal presentation. I will ask each of our speakers specific legal questions to guide the conversation. And at the end of the discussion, I will present briefly Georgia and Georgia's legal model, which different quite substantially, offering a regulated and structured path for certain categories of international intended parents. Now I'm honored to introduce our panel of expert speakers. From Argentina, we welcome Ms. Silvina Sanchez, a leading family lawyer with deep expertise in reproductive law. Ms. Silvina has been actively engaged in surrogacy-related litigations and public work. Her insights reflect both legal practice and evolving judicial trends. In a country that's currently lacks dedicated legislation for surrogacy, but continues to move forward through legal cases and legal innovation. From Mexico, we are joined by Ms. Leon Altamirano, founder and owner of the Altamirano Legal. Ms. Leon is widely recognized as a pioneer in surrogacy and reproductive law in Mexico. With over a decade of expertise shaping legal practice in this area, his deep understanding of regional legal difference offers essential guide for international intended parents navigating the Mexican legal patchwork. And from Colombia, we have Ms. Marta Rita Gomez Hongwe, as a respect expert in family and health law. Ms. Marta Rita's work as an intersection of law, ethic, and medical practice, with specific focus on assisted reproduction of legal parentage. In Colombia, where surrogacy exists within large jurisprudential and bioethical framework, her practice perspective will be extremely valuable for our discussion. Please note, everyone, Ms. Marta will speak in Spanish, and her remarks will be translated into the English by our translator, Ms. Lucrecia Tetenmandi. We thank Lucrecia for her support and appreciate everyone's patience as we will take a few minutes for translation during the part of the discussion. Thank you again for everyone for being here and attending our webinar. I think first we will start with Argentina. Ms. Silvina, could you explain how Argentina's legal system works? Argentina, as we know, Argentina doesn't have specific surrogacy codified code. Could you explain how the process works in legal terms? Thank you. Yes.
There I am. So thank you very much. It's a pleasure to be here again. I will start saying that even when Argentina doesn't have a law that regulates surrogacy, surrogacy is very spread. We do surrogacy in Argentina with high standards. We try to apply international standards just regarding what our tradition in family law we have here. Up to June 2024, we had a different situation. And since that moment, we are navigating a new surrogacy process here in Argentina, even when we have two legislation projects in Congress and legislators are working on that. What we face now is when we start the surrogacy process, we sign all the documents and we enroll the baby when the baby is born as the baby of the surrogate woman and one of the intended parents that signed the documents and signs about his procreational will. It's not important in Argentina if we have a mother and a father or we have two mothers. Maybe if we have a single mother doing surrogacy, we can enroll her and she's going to be listed in the birth certificate. After that, what we need to do is we can ask the court to give the other intended parent an adoption and step parent adoption. It's working okay. We started to have new cases because since June 2024, we didn't have until like March or April these rulings. And we have already several rulings given the adoption, the step parent adoption to the father or the mother that is not listed in the birth certificate. The other thing is important in Argentina is when you register the baby, surrogate woman last name is not going to be included in the birth certificate. So the baby is going to have the name and the father or mother that is listed in the birth certificate, he's going to have that last name, not surrogate woman last name. When you have that, if you live out in another country, you can go back home with some specific documents that will protect you during the next month, and you can try to adapt the filiation status at home. Some countries are better to do that. And if you want to adapt the baby's filiation status here in Argentina, you will need to remain here for several months, maybe like 6 months, if you want to finish the process here. The path that you choose, Argentina is going to provide you all the documents you need to obtain that. The most important thing is that your life with your baby born by surrogacy is a safe life. You don't need to modify your life, and you're going to be able to go back home provided with all the documents, even when you leave Argentina. When you have a travel authorization, we provide you with a parental agreement just to be sure that the surrogate woman, even when law gives her rights on the baby's filiation, she doesn't want to exercise those rights. So you are going to have the power to decide about the country where you're going to live, the decisions of life you are going to make related to your baby when during the time that you adapt your baby's documents and filiation. That's the picture we have now. Maybe in a couple of months, we have good news and the law is going to be approved. And that law, it's similar to California law, and it takes care of agencies, of protocols, and takes care of babies' filiation. That's the most important thing, and that projects even take care of the babies that were born since June 2024 to adapt quicker
That's
in
great.
those cases.
Yeah, that's
Yes, they
great.
are working. They are very optimistic.
Mhm.
And for the end of the year, maybe, or the very beginning of the next year, maybe we have that law approved. They are working so hard
Oh,
on that
that's definitely
project.
great news because if
Yes.
law will be changed, it will be much easier for everyone, especially for intended parents to avoid extra paperwork.
Yes.
Could you clarify regarding, for example, if there's any specific requirement currently for intended parents, for example, regarding genetic linked or age limit?
Okay.
Yes.
Um, we don't have age limits, but when we apply international protocols, we try to have parents up to 60 years old. And if we sign documents with them when they have already 57 years old, we ask them to design a tutor or guardian for the baby, just to be sure if something happens, the baby is going to be with somebody they decided to take care of the baby. Normally, if it's a single father or single mother, we ask that. If they are a couple and one of them is younger, we don't ask them to sign that. In Argentina, genetic connection is not important. We have a very good law that regulates donation, genetic material donation. So for Argentina, if you have procreation or will, nobody's going to ask you anything else. You don't need to prove DNA connection or genetic connection with your baby to be listed on the birth certificate.
Okay, I see. I think Miss Marta has one question. Yes, please. Yes.
Hola Leo Altaminaro, ¿cómo estás? Te conozco. Silvana también. Hablamos todos español. La única que no habla español es Tamara. Creo que el ejercicio deberíamos hacerlo al revés porque me estoy quedando sin la información de, por ejemplo, de Silvina. Entonces, pues es una sugerencia. Sé que la que no sabe hablar inglés soy yo, pero si todos hablamos español y la traducción se podría hacer más tarde para Tamara, pues creería que deberían, ayúdenme con esto. Me estoy perdiendo de toda la información de Silvina. Cojo cosas, sé que ya yo me sé la historia en inglés, pero no lo estoy cogiendo con la definición que debería tener.
So Miss Marta was just mentioning the fact that since the lawyers here speak Spanish, she was wondering why they couldn't necessarily speak in Spanish, so she could follow the information and then have the translation done afterwards. Um,
Yeah, sure. That also works if lawyers are comfortable with this.
Yo no tengo am, ningún problema con ello.
Perfect.
I'm okay.
Perfect. Thank you.
Thank you.
We can continue in this case with Miss Silvina. Yes, I can. I think I can hear you now. Yes, we were talking about age limit and genetic link, which is great news. So there's no any specific restriction. And I just had like one question about you mentioned court process if intended parents want to stay in Argentina to finalize court process about parental rights. Do you know like approximately if there have been any finalized case or how long it will might take? Because maybe there's specific jurisdiction for intended parents who prefers to stay there and wait, and they are okay with the timeline.
I will speak in Spanish. Hay casos ya que hasta hace unos meses no teníamos, pero ya transcurridos unos meses desde el mes de junio del 2024, ya tenemos casos definidos. Algunos jueces, al ver que el niño reside en el exterior de la Argentina, porque cuando iniciamos el proceso el niño ya está en casa, el juez decide que el juez que tiene que ocuparse de decidir el estatus de adopción del niño es el juez que corresponde al centro de vida de la familia. Otros jueces aceptan que aun cuando el niño vive en el extranjero de Argentina, ellos son competentes para entender. Entonces nosotros les aconsejamos a los papás que si no quieren estar en la Argentina, porque se entiende que estar 6 meses aquí es complicado, que pueden iniciar el proceso en su país. En la mayoría de los países, salvo algunos casos muy específicos, proceden adecuadamente con el proceso de adopción por integración, se le llama, o adopción de la pareja del padre que está en el certificado de nacimiento. Y en otros casos, si en su país no es bien recibida la adopción, ellos se quedan aquí. Estimamos un plazo de 6 meses para terminar el proceso de adopción, pero no está representando ningún inconveniente en los casos en que tenemos en trámite. Y si los padres desean seguirlo en su país, sí saben que van a requerir de la colaboración de la mujer gestante para algunos trámites en los procesos en su país y tampoco se ha revestido ningún inconveniente en la participación de ellas en ninguna entrevista o en ninguna audiencia con los jueces en el país donde la familia reside. Eso está bien, está funcionando bien. Hay que tener paciencia, pero está funcionando muy bien.
Okay, so in regards to the outlook that we're looking at right now in these cases, we can, for example, take all of the cases from June 2024, in which we're seeing a favorable resolution rendered all in favor of the parents. So in this case, normally this is done through adoption, which is done through a family law lawyer. So of course there may be a little bit of issues regarding deciding which jurisdiction is the correct one. And this is why sometimes it takes a little bit more, and that's why sometimes they recommend not to stay in Argentina, just in case the parents aren't willing or unable, of course, to stay for these 6 months. This is generally why the process is started abroad, and there are no issues regarding this. Normally, this is just done through adoption, through integration is technically the word, in which the partner adopts the child of the person who is appearing in the birth certificate. And this is normally done quite well and quite efficiently. They haven't seen any issues. This is, of course, unless there is a country that they don't legally recognize the adoption. In that case, of course, they will go through different means. But of course, something to take into account is that should that be the process that you're going to be undertaking, you will need the collaboration of the surrogate, of course, during the time that you are abroad for any of the court proceedings that they will require her presence for.
I understand. Yeah, that
Lo
makes
que,
sense.
I will add something.
Yes.
Lo que también le proveemos a los padres antes de que dejen Argentina es un DNA test para que ellos puedan en su país demostrar que quien dio a luz, la mujer gestante, no tiene relación genética con su hijo. No, no hace falta probar que ellos sí la tienen, sino que no tiene la gestante relación con el niño. Eso es importante en todos los países de destino.
Okay, and something that's generally recommended for your country of origin is to take a DNA test in which you are proving through this DNA test that the surrogate has absolutely no biological link to the baby. Okay, it's not so much the emphasis putting on the parents being biologically linked, but the surrogate not having any sort of material shared with the child.
Yes, I understand. And currently, how long it will take, for example, to obtain a birth certificate, and in total, usually to finalize all the Argentinian paperwork. Of course, doesn't include all the home country embassy and their paperwork, like purely Argentinian paperwork. How long it will take?
Normalmente el certificado de nacimiento es emitido en un plazo de 3 días y a partir de allí estimamos 3 semanas más. Nosotros siempre les decimos a los papás que sin contar los trámites en su embajada correspondiente, la documentación argentina les va a llevar 4 semanas. Durante esas 4 semanas, ellos podrán iniciar en determinadas embajadas alguna presentación, pero para tener toda la documentación argentina son 4 semanas, más o menos.
So Ms. Domino was asking when the birth certificate will be able to be issued, and Silvina was mentioning that this generally takes about 3 days, so 3 business days, just to get the birth certificate itself. And then in regards to the rest of the paperwork, so not in regards to any of the embassy documents, just for the Argentine documents, it would take roughly about 4 weeks. Okay, so a month. And of course, during each of these stages, you can begin some of the procedures that are required by the embassy.
Oh, I understand. And is there any specific issues usually intended parents are having while they're staying in Argentina? I mean, probably legal issues to obtain birth certificate, or is there any specific documentation they need to take care? You mentioned also parental rights documentation, also travel authorization. Is it obligatory documentation they need to obtain while they're in Argentina?
No, no es obligatoria. En principio, nosotros no observamos ningún inconveniente con la documentación si los consentimientos y los términos de los acuerdos y documentos a presentar ante la autoridad son correctos. No observamos ningún tipo de observación por parte de la autoridad en el momento de inscribir al niño. En cuanto a los acuerdos de parentalidad, no es obligatorio. Nosotros tratamos de proporcionárselos para que ellos se vayan un poco más seguros, porque muchos papás al momento de salir tienen alguna inquietud o piensan que al llegar a su país, si tienen que ir al médico, si tienen alguna cuestión de vida de su niño. Entonces nosotros siempre tratamos de proveérselos. Es un acuerdo que hacemos ante un mediador del Ministerio de Justicia, en donde la mujer gestante explica que aun cuando la ley argentina le otorga derechos, ella no tiene voluntad de ejercerlos, los derechos de parentalidad, y le da toda la potestad de decidir sobre la vida del niño al padre que está contenido en el certificado de nacimiento. Hay padres que deciden no llevarse ese acuerdo porque sus abogados en casa les aconsejaron que no, o algunos padres piden algún documento especial emitido por sus abogados en su país. Nosotros 90% de los casos no tenemos inconveniente en firmarlos, salvo cuando esos acuerdos que envían desde el país donde el bebé va a residir se contradicen muy expuestamente con la ley argentina. Por ejemplo, en la Argentina la adopción privada no está aceptada. Entonces, si esos documentos contienen términos de adopción privada, de renuncia al niño, esos términos en la Argentina no se utilizan. Entonces, en 90% de los casos los firmamos, en otros pequeños, una porción pequeña, adaptamos en conjunto con el abogado del país de destino los términos del documento, y normalmente ellos se van de aquí con el acuerdo firmado ante un mediador del Ministerio de Justicia.
Bueno, Tamuna estaba preguntando acerca de cuáles son los panoramas legales, cuáles son las documentación que en la que se tienen que ir y si se requiere la responsabilidad parental explayada en algún lugar o una autorización de viaje.
Lucre en English.
I was just translating the question so
Okay.
the lawyer can also
Okay.
understand that.
I'm sorry.
And now the answer for the IPs. So,
Yo lo supe, lo
in
supe, lo
regards to
supe.
any documents that they are obligated to have, this isn't necessarily the case. So, beyond the informed consent, which of course is a requirement, they don't necessarily need the travel authorization or parentage order. This is something that is often offered to the parents just to give them more peace of mind or just to be able to meet any sort of specific requirements that their private lawyers may request. So, for example, one of the things that they issue is the travel authorization, which is signed between the parties before a mediator, in which the surrogate is claiming that she would not like to exercise her rights of parental responsibility to which she is entitled, and that she is granting that unilateral decision to the father or whoever appears in the birth certificate to make those decisions. So, in regards to any sort of travel, anything medical, or anything in that regard, and of course, any sort of special documentation that a lawyer might be requesting, for example, something done through a parentage order. However, documents that cannot be issued, of course, are documents that might directly contradict anything that has to do with the legal framework in Argentina. For example, we don't have the legal figure of private adoption. So, were there to be a document in which they are stating that the surrogate no longer has the rights of parental responsibility, given that that isn't possible and according to our law, that wouldn't be able to be issued. But they
Understand.
see no issues regarding
Yeah.
that.
Oh, that's great information. And overall, we covered most of the important parts, the steps and restriction regarding Argentina. And I wish there will be new law adopted by end of the year because this will bring a lot of clarity and also much more safety for the Argentina as a like future destination for the intended parents. And thank you, Miss Sylvia. This was really helpful, definitely for me, and also I'm pretty sure for the intended parents too. And I think we can move to Mexico because it has also interesting regulation regarding surrogacy. And thank you for joining us, Miss Leon. I will have
Thank you.
a couple of questions with you because as we know, surrogacy is state regulated in Mexico. How is regulated, for example, which state is currently allowed surrogacy or under what law condition? Is there any like codified law or just more like about practice and court established case laws?
Okay, so I'll address my answer in Spanish,
Yes.
as per Margarita requested. Um, hay una hay una situación con la pregunta, porque la subrogación, que en realidad el nombre correcto, el nombre legal en México es gestación por sustitución, es el nombre correcto de surrogacy en México, no es regulada por los estados, ¿sí? A diferencia, por ejemplo, de muchos países que son vamos a llamarle nacionalistas, o que sus leyes se regulan por, por todos los estados que conforman la República. México sí, de los 32 estados, cada uno tiene su ley estatal. Sin embargo, eh, la gestación por sustitución en México no va regulada por los estados, sino por la Suprema Corte de Justicia de la Nación, que es la máxima autoridad judicial en México. Entonces, en México, la gestación por sustitución, conocida primeramente como maternidad subrogada en 1997, actualmente cambió el nombre en junio de 2021 a gestación por sustitución y está reconocida, autorizada por la Suprema Corte de Justicia de la Nación. Entonces, empezando con ello, no está regulada por estados, es una sentencia que dio la Suprema Corte de Justicia de la Nación y una orden por medio de la cual ordenó a los 32 estados de México a que regularan pro gestación por sustitución. Entonces, tenemos por ahí esa pequeña eh, corrección en la pregunta. Lucrecia, no sé si quieres empezar con la traducción a esto para no
Vale.
alargarlo tanto.
Okay. So he was just mentioning that actually this question is a lot more complex than it would seem at first. So in regards to Mexico, when we're talking about surrogacy, it's actually called gestational substitution, technically, and it is regulated. However, as you would see, each state is able to establish their own state law. However, this has been regulated by their Supreme Court, which in the legal hierarchy, okay, it is at the peak. So they issued a resolution in which they dictated that all 32 states would be having to render in favor of a surrogacy and establish a legal framework. So this was originally established, they were called Mothers Through Surrogacy in 97. And 2021, it's when this new legal framework appeared and was established by state law through the sentence of the Supreme Court. So this is just one little thing of the idiosyncrasy and surrogacy in Mexico that he would just like to correct in regards to the question.
Okay.
Ahora bien,
Yes.
ahora bien, la sentencia de la Suprema Corte de Justicia vino en relación a lo que se inició como una acción de inconstitucionalidad en Tabasco. Tabasco siendo el primer estado en regular la gestación por sustitución, como decía, en 1997, a partir de junio del 2021, cuando se da la resolución a la acción de inconstitucionalidad por parte de la Suprema Corte de Justicia, se estableció que la gestación por sustitución debe de ser accesible no solamente para parejas mexicanas, puesto a que la infertilidad no es un problema endémico de México, no es un bueno, en este caso dijo, no es un problema endémico de Tabasco como estado, ni siquiera es endémico de México, sino que de acuerdo a la Organización Mundial de la Salud, la infertilidad es un problema que atañe a todo ser humano. Por lo tanto, si México tiene la forma de combatir dicha enfermedad, siendo esta la infertilidad, entonces todas las personas tienen acceso a ella, tomando en cuenta que la Constitución mexicana establece que en el territorio mexicano todas las personas están protegidas por los derechos que emanan de la Constitución y tomando en cuenta que también tenemos como premisa la no discriminación ni por nacionalidad, ni sexo, ni género, ni modo de haber sido concebido, que es una de las más interesantes. Entonces, esa es la razón que hace que México sea un destino realmente para todo el mundo, porque no hay ninguna distinción realmente a que si lo pueden hacer parejas heterosexuales, del mismo sexo, hombres solteros, mujeres solteras, incluso personas trans. Eso es lo que hace que la gestación por sustitución o la subrogación en México sea tan atractiva para los padres de intención de cualquier parte del mundo.
So this resolution was issued by the court as a decision in order to combat what was considered an inconstitutional act. So the first state in 97 that was seeing this surrogacy legal framework in June of 2021 presented the inconstitutionality of prohibiting surrogacy. And when the court decided that this should be legal, they also decided that this should also be accessible. Now, it's not only accessible to Mexican citizens, it's accessible to foreigners. And why is this? They say that the problem of infertility is not something that just affects Mexican people. This is something that, according to the World Health Organization, affects everyone worldwide. And so everybody should be able to have the right to have access to this sort of process. That is why Mexico is particularly attractive in this regard, because they protect the constitutional rights not only of their citizens, but also they ensure not to discriminate any sort of foreigners. This makes it a perfect international context to be able to give access either to heterosexual couples, homosexual couples, single parents, or trans people to be able to have access to the opportunity to surrogacy.
No, that's great, because that means there's no any specific restriction for intended parents. But is there
Exacto.
any like age limit or genetic link that is needs to be taken into account? For example, can double donation be done in Mexico?
Sí, la situación con quiénes pueden tener acceso y bajo qué circunstancias pueden tener acceso a la subrogación en México. Eh, en el 2018, la Suprema Corte de Justicia de la Nación creó la figura legal conocida como voluntad procreacional, ¿sí? Entonces, esta voluntad procreacional la puede ejercer cualquier individuo, cualquier ser humano, independientemente de cuál sea su nacionalidad. Y la finalidad de la ejecución de esta voluntad procreacional radica en que no solamente aquellas personas que, que quieren ser padres a través de la gestación por sustitución, aportando el material genético, puede tener acceso a ella. De hecho, cuando la Suprema Corte de Justicia crea la voluntad procreacional, la creó teniendo como contexto que uno de los padres no había aportado el material genético. Entonces, cuando esta pareja llevó al registro civil la petición de registrar al bebé en base a esa voluntad procreacional, el registro civil le dijo, no podemos ponerte como papá, puesto a que tú no aportaste el espermatozoide, esto fue un donador, por lo tanto, va a aparecer la señora que hizo la petición como madre de intención, que sí aportó el óvulo, ¿sí? A ella sí le dijeron, tú sí puedes aparecer en el acta de nacimiento. Entonces esto lo llevaron del ámbito local, lo llevaron al federal mediante un juicio de amparo, mediante el cual el juez federal al final dictó que sí es posible que la persona que no aporta el material genético pueda acceder a los derechos parentales, puesto a que fue su intención desde el principio del procedimiento convertirse en padre, y que al estar limitado genéticamente a aportar el material genético de calidad para poder realizar el in vitro, optó por un donador de esperma, y él recibe este material genético como suyo, y al aportarlo al procedimiento del in vitro, lo aporta como si fuera de él. Y ahí se convierte la voluntad procreacional en recibir un material genético donado para tomarlo como sí y crear el embrión correspondiente. Y de ese embrión, una vez transferido al útero de la madre gestante sustituta, el resultado o el bebé que resulte como nacido como resultado de esa transferencia del embrión, este bebé va a ser del padre de intención. Y lo mismo sucede con el de la madre. Veía en el chat del seminario que alguien preguntaba si era posible que dos personas sin aportar material genético pueden ser padres a través de este método. La respuesta es sí. a través de precisamente la ejecución de la voluntad procreacional, padres de intención que no aportan el material genético pueden convertirse en padres a través de la gestación por sustitución en México.
Okay. So in the short answer would be yes, because it has to do with the procreational will that the parents are giving during the surrogacy process. So within the context of this first case that actually set the precedent, one of the things that they were saying was that the parent who had not given any sort of biological material to the child would not be able to be appearing in the birth certificate as the father was technically an anonymous donation. So the only person that would be appearing was the mother in this case, who had actually given a biological sample. When this was sent to a federal case and the resolution was issued by the Supreme Court, they made this figure in 2018, I believe, named procreational will, in which they stated that given that the surrogacy was done on the basis of having a sort of genetic limit or limitation by one of the parents and having to require the use of a donor, that this process would be what would essentially be expressing and establishing the procreational will of the party who is unable to give any sort of biological sample. And that would mean that the baby, which would be the result of this surrogacy, would be assigned to the parents who express procreational will, which of course is not the surrogate in this case.
Oh, okay. So even in that specific landmark case, that we can call that, there was like only a sperm donor was used, but was there any case that double donation was done? For example, both of the biological material was like provided by the donor. Will it be okay for the intended parents to pursue surrogacy in Mexico in this specific case?
Yes, double donation, it's okay in Mexico by the execution of the procreational will.
Perfect. And I think I have one more question. When the baby is born, usually how long it will take to finalize the Mexican paperwork, including birth certificate or court proceeding, or how to obtain the birth certificate too?
Ok, la situación con el proceso de salida en México va a depender muchísimo de qué nacionalidad es el padre o la madre de intención, siempre, ¿sí? Sobre todo por el hecho, y para darte un ejemplo, padres de intención de Países Bajos, no es recomendable que hagan subrogación en México. ¿Por qué? Porque se tiene que ajustar la legislación mexicana a la legislación de Países Bajos. ¿Bajo qué términos? La legislación en Países Bajos requiere específicamente del reconocimiento de la mujer que da a luz al bebé en el acta de nacimiento que da la identidad al menor. Y posteriormente requiere de una sentencia judicial que reconozca que la mujer que aparece en el acta de nacimiento no aportó el material genético, que renuncia a los derechos parentales que recibe por medio de ese registro en el acta de nacimiento, para posteriormente dárselos a la madre de intención. ¿Por qué me refiero a este programa o a esto en específico? Porque un padre soltero de Países Bajos no puede ser padre por medio de subrogación en su propio país. En México sí se puede, ¿sí? Todos los padres de intención de cualquier parte del mundo pueden hacer el procedimiento en México y van a cumplir con la legislación mexicana. El problema es cuando regresan a su país. ¿Por qué? Porque la legislación mexicana lo permite, pero la legislación mexicana no se va a adaptar a ciertos sistemas legales de algunos países. Tenemos claro, por ejemplo, que en Italia no pueden, ¿sí? Tenemos claro que China específicamente no reconoce la subrogación. Sin embargo, hemos tenido casos, yo he tenido muchos casos de chinos que viven en China. Hay que hacer también una diferencia. chinos viviendo en China pueden hacer el procedimiento. ¿Por qué? Porque la Embajada de China en México les va a otorgar un permiso de viaje de regreso a China. Pues es lo que sucede, por ejemplo, con Francia, que emite un laissez-passer, que es el pase de regreso a Francia siempre y cuando vivan allá. No les da un pasaporte. Eh, lo que sucede es que independientemente del país de origen del padre de intención o de los padres de intención, va a ser diferente siempre para todos, ¿sí? Para los de Estados Unidos es muy fácil porque Estados Unidos reconoce la subrogación y emite el pasaporte americano simplemente cuando ellos presentan un acta de nacimiento con sus nombres en el acta. ¿Sí? Les emite el pasaporte americano. España no lo permite, no los va a dejar, por ejemplo, no permite que una pareja heterosexual española tenga un bebé por medio de subrogación en México, porque les va a decir, mira, presenta la documentación correspondiente, les pide el certificado del hospital y les pide que en ese certificado de hospital aparezca el nombre de la madre de intención, lo cual no es posible. ¿Sí? El certificado del hospital siempre va a aparecer a nombre de la madre gestante sustituta y no a nombre de la madre de intención. Lo que sí aparece a nombre de la madre de intención es el acta de nacimiento. Entonces, el proceso de salida, o en respuesta a tu pregunta, Tamar, va a diferir el proceso de salida dependiendo de la nacionalidad de los padres de intención.
Okay. So the answer is a bit complex because it's going to vary greatly depending on the nationality of the intended parents. So if we're looking specifically, for example, at the Netherlands, one of the things that they require is an acknowledgement from the surrogate um, in the birth certificate that she didn't give any sort of biological link. This is later reaffirmed through a court sentence in which she reiterates the fact that she did not give any sort of biological link, nor does she wish to have the parental responsibility over the child, and that she will be giving any sort of decision over to the intended parents. Um, but however, he's aware that single parents aren't able to go through the act of surrogacy. If we are looking at, for example, China or Italy, they have issues with recognizing surrogacy. So, of course, the Mexican legal framework is only going to be able to adapt so much. Of course, it will not be able to alter itself completely. For example, in the case of China, they do have certain cases in which they are Chinese citizens living in China who are able to proceed, given that they go to the Chinese embassy and they're allowed to receive a sort of pass back home, which isn't necessarily the same sort of documentation issued in other cases. USA, for example, is also quite easy to be able to do surrogacy in Mexico, given the documentation. However, in Spain, there are quite a few limitations. And in this, one of the issues is, for example, that should they have a heterosexual couple that go through surrogacy in Mexico, one of the things that they will request is the certificate from the hospital, which is different from the birth certificate issued by the registry, has to have the intended parent's name. However, the hospital record would only have the name of the patient, so the surrogate, and they wouldn't have the intended parent's name. So these are the sort of contradictions which you can find in the legal frameworks, which may make it difficult. So you would have to evaluate on a case-by-case basis, depending on the nationality.
Yeah, I understand. But usually when baby is born, within like how long it will take, how long it takes. For example, generally intended parents need to stay in Mexico to finalize purely Mexican paperwork, including birth certificate and, if necessary, court proceeding and court decision.
Okay. Una vez que nace el bebé, ese mismo día o al día siguiente nosotros solicitamos el registro al registro civil. Les solicitamos el acta de nacimiento. Regularmente, o mejor dicho, en cada caso, el registro civil niega, o mejor dicho, condiciona el registro de ese bebé a la presentación de una sentencia emitida por el juez de familia. Al momento de que el registro civil solicita esta sentencia, automáticamente es una negativa. porque esa sentencia no se obtiene, ¿sí? No se cuenta con ella. Entonces, es cuando nosotros presentamos un juicio de amparo, ¿sí? La presentación del juicio de amparo nos va a tomar aproximadamente, en el mejor de los casos, de 3 a 4 semanas, pero regularmente está tomando entre 4 y 6 semanas para que tengamos la orden para poder hacer el registro del menor. Y recordemos, esta orden del juicio, esta orden federal, es para que sea el nombre de los padres de intención en el acta de nacimiento, ¿sí? No se pone el nombre de la madre gestante sustituta. Y esto es para todos los tipos de padres de intención, sea padre soltero, madre soltera, pareja del mismo sexo aunque no esté casada, incluso padres trans, ¿ok? Esto es para la obtención del acta de nacimiento sin la gestante, mediante orden judicial en un juicio de amparo. Respuesta a tu pregunta, de 3 a 4 semanas, en el mejor de los casos, de 4 a 6, en un caso donde nos nieguen el amparo en primera instancia y tengamos que presentar una queja, que pasa muy, muy poco.
So generally, once the baby is born, either on that day or the next day, they will be requesting the civil registry to issue the certificate. So how the internal procedure works here is they're technically going to request a certain conditioning to be able to issue the certificate, in which they request a court from family law to issue a sentence in their favor. This is automatic. It will be automatically rejected, which is to say that the civil registry will essentially reject your request for a birth certificate, in which the lawyers will then request un amparo, which is an injunction relief, to be issued, which takes, in the best cases, from 3 to 4 weeks. But generally, it's about 4 to 6 weeks, in which they will request that the court authorize them to register the baby under the name of both intended parents at the birth certificate. So that would mean that the surrogate would not appear with her name in this birth certificate. Okay.
Yeah, I understand.
And this is independent of whether the intended parents are single, married, or a part of the LGBTQ plus community or not.
Understand. That's pretty clear, I would say. It's pretty strict and follow their guidelines. So I think we cover most of the important part of the Mexico, yes. All the necessary steps that need to be taken in account. And especially we know that there's not any specific restriction, and that's the great news that Mexico government, I would say, like, law approach the foreigners as their citizens and they're protecting their constitutional right, which is, I would say, pretty great advantage for Mexico. And now we can move to Colombia, who has also a really interesting legal framework regarding surrogacy. Hi again, Marta. I'm glad you're
Ay,
a webinar. So, could you explain, for example, how is regulated surrogacy in Colombia, and if there's any special restriction for intended parents about age limit or about their gender or genetic linked?
bueno, en
Through
Colombia no existe la regulación como tal, tiene tres fuentes de derecho: la Constitución del 91, una ley del 98 que dice qué pueden y qué no pueden hacer las clínicas de fertilidad, y varias sentencias que han hablado sobre la subrogación. Sentencias que en Colombia, debemos recordar, no tenemos un derecho basado en antecedentes jurisprudenciales, sino que es de derecho positivo, es lo que diga la Constitución y la ley. La Constitución dice en el artículo 42 que podremos tener hijos por asistencia científica, pero además dice que podemos tener cualquier tipo de familia, lo que hace que haya diversidad y no nos van a decir que no pueden ser singulares, heterosexuales, homoparentales, sino que nos dice que podemos tener cualquier tipo de familia como lo pueda y lo quiera tener el ciudadano. También que somos iguales y que todo el que llegue a Colombia se le aplicará la constitución política, lo que hace que no haya exclusión para los extranjeros. Con respecto a la ley, el Código Civil colombiano sí es muy específico frente a las presunciones de filiación. Y una de las presunciones de la filiación es el del matrimonio o el de la unión marital. De hecho, si estás casada o en unión marital, de hecho, con el otro, tienes inmediatamente la posibilidad de alegar que también es tuyo, y debes aportar, obviamente, como lo hemos sabido, el consentimiento informado o la contratación previa para determinar que como familia tomaron esa decisión. Y la tercera fuente son las jurisprudencias que ha habido. La más importante es la de 2009. Y en el 2009 se dice que se llamará subrogación uterina o subrogación por gestación subrogada. Y no se puede decir sustitución porque ya existe ese concepto en nuestra legislación cuando una mujer se queda cuidando a unos niños que no son de ella, y se llaman madres sustitutas, que son las madres que trabajan para el Instituto Colombiano de Bienestar Familiar, que es una institución que se encarga de los niños abandonados. Por eso no se podía hablar de una gestación sustituta porque ya existía ese concepto. Eh, en términos generales, se resume la gestación subrogada en Colombia en 4 puntos que sí o sí deben darse. Uno, debe haber material genético propio de al menos uno de los contratantes. Si no hay de los dos, no habrá posibilidad de hacerlo en Colombia. Tiene uno de los dos que tener material genético propio. La segunda es que la gestante no puede aportar material genético propio porque la maternidad y la paternidad se probará en Colombia a través de exámenes de ADN, lo que significa que si eventualmente esa gestante llega a probar que es de ella, nunca se podrá eliminar a esta gestante del registro civil de nacimiento. La tercera es que debe haber un motivo muy grande para adelantar un proceso de gestación subrogada. Es decir, no es porque queremos o porque nos satisface hacerlo, sino porque no hay un impedimento médico que nos permite ir a este eh, sistema de reproducción que se hace de última ratio, que en latín es última razón para hacer. En el caso de los chicos, de los varones, obviamente, como la sentencia de 2009, el ejemplo que puso fue no tener útero, obviamente ellos no van a tener nunca un útero y lo podrán hacer. Pero si es una pareja heterosexual, la madre biológica debe probar que no puede gestar por alguna razón médica establecida y probada. Y el cuarto punto, que no es menos importante, en Colombia debe hacerse de manera altruista. Entonces, toda nuestra documentación está más determinada a decir que aunque ella recibe unos dineros por esto, no es por la labor hecha, sino por haberlo hecho de una manera diligente en un embarazo sano que le permitió tener una vida tranquila durante esos meses de gestación y unos meses más, que son los de la licencia de maternidad, que en Colombia son 4 meses y medio. Eso es lo que tenemos. Tenemos una última sentencia del 1 de abril de 2025 que nos obliga casi a que tenemos que adelantar procesos judiciales en todos los procesos. Sin embargo, estas sentencias de tutela y las sentencias de tutela, guardando las proporciones con México, es la de amparo. Y las sentencias de tutela solamente son interpartes, solo obliga a las personas que hicieron y llevaron ese proceso a la jurisdicción. Sin embargo, las notarías no han querido hacer registros directos porque consideran que todas deben irse al proceso judicial. Algunas notarías entienden que es una sentencia de tutela, que es interpartes, no es erga omnes, no es para todos, es para solo ellos dos. Y nos permiten hacerlo cuando, y ahí sí voy hacer un paralelo con México. ¿Cuándo? Cuando sea fácil. Ejemplo, ¿para qué vamos a ir a un proceso judicial si en Estados Unidos no nos van a poner problema? De una vez lo hacemos directo y se va a la embajada y la embajada le da el pasaporte. Pero no lo podríamos hacer así para una España, no lo podríamos hacer así para Italia, porque allá definitivamente no les vale nada. Les vale la sentencia judicial. ¿Ok? Entonces, ya sabiendo del país de origen de los padres de intención, nos dirigimos hacia un camino o hacia otro. Y en este camino también es posible, por ejemplo, para los Países Bajos, nosotros sí podemos pedir que dejen a la gestante dentro del registro civil diciendo que no es la madre, pero que la dejen ahí, el nombre quede dentro de la sentencia. Y para ellos es posible porque allá lo van a recibir en debida forma. No va a tener los derechos de madre, pero va a aparecer en el registro, para darte un paralelo con México. Es decir, nosotros sí le podemos pedir al juez, oiga, señor juez, ¿sabe qué? Déjemela ahí, déjeme a la gestante dentro del registro, pero quítele los derechos. Hay que tener en cuenta otra cosa en Colombia, y es, aquí no hay forma de renunciar a derechos de la patria potestad. La patria potestad en Colombia es un derecho bastante particular y raro que casi ningún estudiante de derecho puede entenderlo en principio. Ya cuando nos tiene muchos años es que lo entiende. La patria potestad es algo más grande que la custodia, cuidado y tenencia. Es como un derecho superior, superlativo, que nunca se pierde. Se puede perder la custodia, se puede perder el cuidado personal del niño y se puede perder la tenencia, pero no se pierde la patria potestad. Y la patria potestad nunca se puede renunciar. Al no poder renunciar, sí se tiene que ir a proceso judicial para que la señora pierda la patria potestad y todo lo demás. Ahora vuelvo con Silvina, que nos dijo que ellos daban una documentación. Yo doy una documentación donde entrego, por voluntad de la gestante subrogada, la custodia, cuidado y tenencia traducida y apostillada al país que vaya, para que esa persona esté tranquila de que no va a haber alguien, porque sí saben que viene de Colombia, van a decir, esta señora tiene todavía derechos, pues alguien que tenga conocimiento de
More
nuestra legislación.
disculpa. Sorry, Martha. It's really better to translate because participant wants to know the whole information because it will be easier to kind of split the conversation or answers so other people can manage to understand the whole process, how process works in Colombia. Thank you.
So we're going to be looking at a few different legal aspects that gave source to these to the legal framework currently in Colombia. So we're looking at the Constitution from 91. We're also looking at a case law from 98, which specifically established what legal framework the fertility clinics will be working in, and then a different case law with different resolutions. Okay. So currently, there is Section 42 in the Constitution, which allows for the having of children through scientific means. So this is already contemplated in their Constitution and already contemplates any sort of family figure. So this allows for diversity, yes, and not requiring a sort of nuclear family, so to speak. Additionally, every citizen is equal in the eyes of the law, as well as any foreign citizen to come into the country. So they would be working under the Colombian legal framework as well. The civil code in Colombia is quite specific in the way that it establishes a different filiation. So, for example, they contemplate both married couples and people that are in de facto relationships. This would allow, as a society, for the people to establish themselves both to have the rights given by law. So, just on the basis of being someone's partner, you would be able to extend and be entitled to the same rights as they are. When we're looking at, for example, the case law issued in 2009, this is where they established the term that they are using, which is surrogacy. Different to Mexico, they can't use the word substitution because substitution is something that they are currently using as a legal framework for guardianship within foster care. So that's why they have a difference in term. And there are 4 requisites that you must have in Colombia to be able to go through the surrogacy. So one would be that at least one of the intended parents has to prove the biological link to the baby. This is a requirement. And second, the surrogate would have to prove through a DNA test, of course, that they don't have a biological link to the baby. So those are 2 very important things that must be proved through the DNA test. Additionally, this will allow them, of course, to remove her from the birth certificate, or not appear, rather. The third would be the motivation. So they have to have a medical basis as to why they are not able to conceive. So, of course, in the case that you would have two men, given that neither of them, if they are cisgendered, would have uteruses, then they wouldn't obviously be able to conceive. That would be their medical basis. However, if we are looking at a cisgendered woman partaking in this, she would have to have a medical certificate or something to prove as to why it is that she isn't able to conceive herself. And the fourth is that this is an altruistic act in Colombia. So, of course, they are aware that there's going to be some sort of compensation given. However, this compensation generally contemplates the basically the covering of expenses for the surrogate during the time of the pregnancy and a little bit afterwards, just for it to be comfortable for her, rather than as a sort of income in that regard. And in 2025 is the most recent update in the legal framework in Colombia, which is through a judicial sentence in which they are now requesting that everything go through a court decision. So the parties are having to request an injunction relief in which requesting that the court remove the surrogate from the birth certificate and allow both IPs to appear. And she mentioned that this is going to be different depending on each of the countries as well. So she said to be able to contrast with Mexico, one of the things that we can offer, for example, for nationals that come from the Netherlands, is that in our case, we can request that the civil registry leave the name of the surrogate in the birth certificate. She would not be appearing as any of the intended parents, but the name can appear there just to be able to adapt to their sort of legal regulations. However, she does remark that they would share the same issue with anyone coming from Spain, for example. So one of the things that's very important to keep in mind is that in Colombia, what they have is patria potestad, which is the parental responsibility. This goes beyond just the custody. She says that that is something that, as mentioned in Argentina, you are not able to waive your rights to. So while you might not have the custody to the child, you are not entitled to waiving your rights of parental responsibility over. So one of the things that they do is, just like in Argentina, they issue a document in which the surrogate is expressing her will to give unilateral decision to the IP rather than take them on herself.
Okay, I understand. Yeah, thank you. And could you clarify also regarding age limit and also genetic linked? What is the restriction if they're because if I understand correctly with my poor Spanish, Marta also mentioned about genetic linked, if there was any restriction currently for individuals, for intended parents.
Yes. So just to reiterate, she said that there are two requirements. One is that there must be a biological link as proven with one of the intended parents to the child. And they also have to prove that the surrogate does not have a biological link. So at least one of the IPs has to be biologically linked to the child, and the surrogate cannot.
Oh, perfect. Could you ask Ms.
Yes,
Martel,
age.
usually how long it will take after baby is born to finalize legal process in Colombia, for example, to obtain birth certificate, or what is the documentation needs to be done before intended parents with the baby leave the country?
¿Y podrías comentar un poco acerca de cuáles son los plazos que se están mirando más o menos para el procedimiento legal y qué documentación se requiere presentar?
Está lloviendo y no me he dejado oír, por favor, ¿me repites?
Sí, que estaba preguntando Tamuna, más o menos cuáles son los plazos que se está viendo actualmente para estos procedimientos legales y cuáles son los requisitos en cuanto a la documentación que se tiene que presentar.
Depende del país a donde vaya, depende del tipo de familia que sea, pero en términos generales, hacer un proceso de registro con la madre gestante para iniciar el proceso judicial no se demora nada, se demora 2, 3 días máximo. Igualmente unos 3 o 4 días para los exámenes de ADN que sí o sí se deberán hacer, tanto para las embajadas como para el proceso judicial. Aquí, a diferencia de lo que escuché de México, si queremos utilizar una acción de amparo, que es una acción de tutela, que ya hice estoy esperando resultados, atendiendo a ese ejemplo. La presentamos hace ya 15 días y ya nos va a salir el resultado. Sí debemos registrar. y la tutela lo que va a decir es cancela ese registro y póngalos a los dos padres de intención directamente. Eso es lo que esperamos. Sin embargo, no es claro hasta el momento porque es nuestro primer ejemplo. Lo que sí es que sí tenemos que ir a proceso judicial ordinario, que sí nos puede demorar de 8 meses a año y medio para que nos salga la sentencia. Por eso la necesidad de llevarse estos padres de intención del registro civil traducido, apostillado, más una escritura pública con toda la sesión de custodia, cuidado y tenencia del bebé para que cuando lleguen al país de origen no tengan ningún problema. En los casos que ponen problemas, porque Estados Unidos no lo pone directamente, se va y no tiene necesidad de nada, va a la embajada con sus exámenes de ADN y se fue. Es dependiendo también del lugar de origen. Pero estamos en un momento de transición muy grande en Colombia. ¿Por qué? Porque los jueces están detenidos. Yo creo que llevamos unos 6 meses donde no ha salido una sentencia porque ellos quieren saber cuál va a ser la decisión del grupo de notarios para ver si lo hacemos directo o si nos vamos a proceso judicial.
Okay. So this depends. It depends initially on the country of origin, on the family. So she says that generally the family is requesting that the civil registry move forward with the process and they go to court. So this takes about 2 to 3 days. It's immediate. Then there's about 3 to 4 days for the delay to be able to get the results of the DNA test. So this is both for Colombian documents and for the embassy documents. Some of the differences that she can mark, for example, with Mexico, is this injunction relief that is requested. She has a specific case in which they requested this injunction relief, and 15 days afterwards, they had the resolution issued. Then after this, they will be requesting that the court remove the surrogate and put both of IPs. However, how long this may take is a little bit less certain, given that, of course, given that it's the court system, it can delay. So she's looking currently at about 8 to 12 months. And that is one of the reasons why they request that the parents make sure to get the public deed and the birth certificate entitling them to the custody and the taking care of the child. But once again, this is dependent on the country of origin. For example, in the USA, in which they have less requirements or restrictions, and in which they would just need the DNA test to be able to prove the link, they would be issuing the certificate much faster. But she also does remark that they are right now transitioning at this moment in time. There's a change in the legal framework, and right now she has about 6 months. She's seeing the judges about 6 months from now stopped with all sentences, not issuing any sort of judgment, and just waiting to see how it's going to proceed before continuing.
Okay, I see. Understand. That's interesting. And currently, as I remember, there was new court decision in April. Did this Supreme Court decision have changed any approach to surrogacy, or did they establish any extra paperwork for intended parents?
Y en cuanto a la resolución judicial que se emitió en abril de este año, ¿esto tuvo algún impacto en cuanto al panorama de la gestación por subrogación o de la documentación que se requiere?
Sí, sí lo tuvo, porque las notarías quedaron todas diciendo que no se podía hacer de manera directa y nos mandó a todos a hacer procesos judiciales. Algunas notarías pensaron, como ellas tienen un servicio público de carácter privado, así es el servicio de notaría en Colombia, ellos pueden decidir eventualmente que sí lo pueden hacer. ¿Quiénes son las notarías que lo están haciendo? Las que saben que no van a tener ningún inconveniente, como por ejemplo los padres de intención de Estados Unidos, pues lo hacen. Pero cuando hay un varón solo, es difícil que lo hagan, salvo que ese país de origen no vaya a ponerle dificultad. Ejemplo, Perú. Perú no va a poner dificultad, lo deja hacer. Pero Argentina sí pone dificultad. Entonces Argentina dice, la embajada de Argentina en Colombia dice, no, el señor no pudo haberlo tenido solo, no es posible, no le dio pasaporte, entonces tocó anular el registro e irnos a proceso judicial. Casi que de cada nacionalidad nos vamos tropezando o con embajada o nos vamos tropezando con el juez o con el notario. Es sabiendo quién y cómo nos va dando un espacio. Lo cierto es que en Colombia no es posible que lo prohíban porque es de orden constitucional. En Colombia no es posible que haya más restricciones, tendría que cambiarse la constitución y nadie está pensando en cambiarla. Y lo otro es que la ley, que es antigua, que es de 1892, que es el Código Civil, permite las familias integradas con un hombre soltero o una madre soltera o parejas homoparentales. Es increíble que desde 1892 eso ya se podía hacer y nadie lo ha derogado. Significa que tenemos un acervo legislativo muy fuerte que no permite que haya una prohibición.
Mhm. Okay. So yes, this did impact because generally the notary publics are able to sign according to their own criteria and discretion. However, the only ones that are doing so now are the ones who are sure that they're not going to have any issues should they make this private deed public. So, for example, those who have IPs coming from USA, given that they know that there are going to be no issues in the issuing of documents. This is also the same in Peru. However, one of the issues that they can have is in Argentina, for example. Should they have just one father on his own, the Argentine government would be requesting the information of who the other person giving the biological material would be, given that it's not possible to have the child alone. So once again, it's going to be depending on the different nationalities of the clients. One of the things that she also can mention is in Colombia in 1892 is when the Civil and Commercial Code contemplated this family structure of just one person. And that's why she says that's something that you can make sure of is the fact that the legal figure of surrogacy in Colombia is quite safe and can't be altered, particularly because in the Constitution, they see the family unit as being able to be made up of just one person, for example, or by homosexual or heterosexual couples. So, despite the changes, something that she can assure is that surrogacy will always be possible in Colombia.
Oh, that's great. Thank you for the information because I heard on the internet there's like a lot of Indian parents was worrying about the new legislation, more like new court decision regarding surrogacy in Colombia, and they were worrying this will change a whole landscape and it will kind of affect, or outside they were stipulating that it will lead us to banning surrogacy in Colombia, and it is good news. It's most likely affecting the whole process, not in a bad way. I think we covered most of the important things in Colombia, and considering we have also time limit for the webinar. Thank you for Marta for your time and explaining all the details. I will also want to approach a little bit about Kuchu in Georgia because compared to all the three countries what we have covered so far on our webinar, Georgia has much more different approach because currently Georgia is available only for heterosexual couples who have been married up to 1 year or have been in a relationship up to 1 year. More than 1 year, for sure. Yes, this is the specific I would say requirement by law this Georgia government established for the people who want to pursue surrogacy in Georgia. The main difference also what Georgia established for Indian parents is that when baby will be born, Indian parents will be included on the birth certificate as a parents. And by law, surrogate mother and donor does not have any parental right over the child. They cannot claim anything from the Indian parents. And compared to, for example, to Colombia, Georgia is provides as a commercial, also altruistic surrogacy models. Most important that when you're signing surrogacy contract, you need to sign in front of the notary, and notary need to approve the surrogacy contract, and you can include financial details because I would say Georgian government believes that as long as the party agrees on this detail and there's nothing illegal, it is possible to pursue the surrogacy. And important is to both parties' rights need to be protected, and government wants to make sure that surrogate mother's rights are protected and she will receive the fair compensation. And of course, fair compensation is usually established by the market. Unfortunately, we need to use these words because it depends how is the demand and what kind of compensation will be established by the itself surrogate mother as a fair for them. I would say it's one of the difficult part for Georgian surrogacy process is about embryo shipment if you're shipping embryos from foreign country to Georgia, because if you have used the donors, you need to provide us a power of attorney obtained by the donor, and donor needs to this information needs to be public. You cannot use just anonymous donors from the egg bank or sperm bank, unfortunately, because all the information needs to be provided to Georgian governments to issue the birth certificate. I would say this is the main difference. That's why the Georgia is a little bit limited for the intended parents who want to pursue the surrogacy, especially for single parents because they cannot do surrogacy in Georgia, as but based on the regulation. There was one question on the group chat asked regarding embryo shipment in the countries, because as I mentioned, Georgia is a little bit complicated because Georgia government asks a lot of paperwork, which will be also provided for the government after baby will be born. And every country under that definitely, I believe, have their regulation regarding embryo shipment. Can our panelists just say maybe for 1 minute to explain how usually embryo shipment is done in their country? Is there any specific regulation, or does it has because there's surrogacy involved, does it affect the embryo shipping process? For example, we can start the same order. For example, Miss Slovenia, could you explain if there's any specific, yes, if there's any specific regulation regarding this part?
Hay una regulación de traslado de material genético que está regulada por una ley. En la Argentina no tenemos ninguna restricción, no se pide información sobre el destino que se le dará a los embriones que son enviados desde otro país hacia la Argentina. Algunos países desde donde el embrión sale, esos países piden información, pero no Argentina como receptor. Los trasladan courier certificados privados luego de complementar determinada documentación en aduanas y Ministerio de Salud. Es un procedimiento rápido y muy usado en la Argentina. Incluso los médicos y las clínicas no tienen inconveniente en recibir embriones desde otros países. Por ejemplo, como una diferencia, Estados Unidos suele no recibir embriones de otros países porque usan determinadas técnicas distintas de descongelamiento. Entonces, ante el riesgo de malograr el embrión cuando lo descongelen, prefieren no recibir y generar el embrión en los Estados Unidos. Argentina no tiene ese problema. Lucre on
Okay.
mute.
Yes. There are certain regulations in regards to the shipping of biological material. She mentions that in Argentina there are no specific requirements. They also do not ask you to justify what you're going to be using the biological material for. Generally, this depends on the country of origin, which they may sometimes ask that you explain to them what you're going to destine them for. This is a system that is very used here in Argentina. The clinics generally have no issues receiving also embryos that were created abroad, which, sometimes in certain destinations it is an issue. For example, in the United States, given that they have different thawing techniques, they generally don't like to accept embryos created abroad. That isn't an issue here. That isn't an issue here in Argentina. You just have to make sure that you go through a certified courier. You request the process be done at customs and at the health department, and it's quite simple.
Thank you. Mr. Leon, could you explain if there's any specific regulation in case of Mexico regarding embryo shipment, especially when surrogacy is involved?
Mexico, it's a nightmare when it comes on shipping embryos. Español. Es una pesadilla México para la regulación de recibir o de importar embriones de otros países. Y esta pesadilla es básicamente porque COFEPRIS, que es la autoridad sanitaria que otorga los permisos de tanto salida como de entrada de material genético o de tejido humano, tiene una aduana en el aeropuerto que cada vez que se trata de tejido humano, tienes que pedir un permiso especial que te puede tardar de 6 a 8 e incluso hasta 10 meses. Entonces, importar embriones no es algo fácil. Digo, po- con eso puedo contestar tu pregunta. En realidad no es recomendable.
Okay. So he says basically it's a nightmare to import embryos into Mexico. Basically, the health authority over there has to issue every time that the biological material is either entering or leaving the country. They have to issue an authority there at customs. They have their own office there. And generally, they're taking up to 6, 8, or 10 months to issue this authority. So he says that just to keep it short and sweet, importing embryos is not easy to Mexico.
Understand. And
It's possible.
yes,
It's possible. Yes, it takes time. That's the issue.
and so as I understand, the most important document is this like health ministries. I would say like can I call it permission?
It is a permit at the end.
Yeah. And
So,
regarding
yeah.
Colombia, we can also cover the Colombia's like if there's any specific regulation about embryos, because as I remember, there was not any special strict regulation.
En Colombia sí
Mhm.
está regulado a través de una institución que se llama INVIMA, pero antes que INVIMA, que es como la institución gubernamental, lo importante es que desde 1998 las clínicas están obligadas a autorreglamentarse y a hacer la trazabilidad del material genético. Entonces, nunca puede una persona como particular enviar ese material. Tiene siempre que ser a través de dos clínicas de fertilidad. Una que esté, por ejemplo, en Georgia o que esté en Estados Unidos, con la clínica donde se va a hacer el procedimiento. No son personas particulares, son centros de fertilidad que tienen la función de enviar y recibir. INVIMA lo entiende, es relativamente fácil desde cuando los centros de fertilidad se dieron cuenta que podían hacerlo desde el 98, sin embargo, no lo hacían porque se requiere realmente de una pericia, de formas, que ya lo saben hacer casi todos los centros de fertilidad, de llenar unas formas para recibir un permiso casi que generalizado para que cuando lleguen esos embriones o material genético, cualquiera que sea tejidos, óvulos o espermatozoides, estén regulados. Lo que tengo entendido porque se sale un poquito de la órbita de mis funciones, es que es mucho más fácil recibir embriones que recibir material genético separado, por decir algo. Más fácil recibir un embrión que recibir semen o recibir óvulos a través de la figura del embima.
So it is regulated there. In Colombia, she was mentioning that since 98, all fertility clinics have to have their own auto regulation in which they have to do their own follow-ups and acceptance of biological material. So one of the things that she was mentioning, for example, is to be able to follow up the procedure. It is not possible for a private individual to go to a clinic and offer a material sample. For example, an individual wouldn't be able to go and give the clinic embryos. It would have to be done through two fertility clinics, which are authorized not only to, of course, send, but to receive this material. And given the different regulation and the different techniques requesting permission, she believes that it is easier, for example, to receive embryos into Colombia than isolated biological material, like, for example, semen.
Yes, I understand. I think we covered this more important question. And so one of the attendees asked this specific question, so I hope we covered the basics, considerable time limits for this webinar. And thank you for all the information, because it was really interesting to see how each country regulates this surrogacy, especially how ethically for some of the countries it might be a little bit challenging to issue the birth certificates or even recognize the parents when surrogacy is involved. And I'm hoping this session was informative and helpful for everyone who was attending this session. And because we definitely covered one of the most popular destinations currently in the world. And if you have any further questions or would like to learn more about legal expertise service or about the lawyers in today's panels, please feel free to contact us and via phone or via email, and we will provide more information and also personal information of the lawyers, and you can get in touch with them too directly. And also, As I mentioned, our meeting is recording, and the recording will be uploaded on our website. So if you want to visit our website, feel free and check our recording later stage. And also, if you need our help, please contact us, and we will provide the recording to you via email. Thank you again for everyone, especially our panelists who provided insightful information about their countries. And I'm hoping, especially for Argentina, I'm hoping the new law will be adopted.
Yes,
So
me
much
too.
for you.
Me too. Yes, we are working on it. Me too.
Yeah, that will be really great. And thank you again for each of
Thank
you.
you.
Thank you, Lucrezia, for your help. Thank you. And
My pleasure.
Thank you.
wish you a lovely evening, because as I know for you guys, it's a little bit over 5 p.m. So thank you again and have a lovely evening.
Thank you.
You
Have a nice
too.
day.
Thank you so
Bye-bye.
much.
It's a pleasure.
Bye bye.
Bye-bye.
Gracias.